Good afternoon, everyone in BC, and late afternoon for anyone joining us from Alberta or Ontario. My name is Darren Sall. I'm your employment lawyer for today's 30-minute question and answer, Facebook Live and YouTube question and answer session. I'm an associate with Samfiru Tumarkin. I work in the Vancouver office, and so this is your opportunity to ask any questions you may have, employment law related, just dealing with your employment, any human rights issues or workplace issues you're dealing with in your employment, either currently or ones you've had in the past or ones you're worried about and experiencing in the future. Now's your best chance to ask all the questions you've always wanted to ask. Don't be shy. I'm here to answer your questions for the next 30 minutes. Yeah, I'm looking forward to hearing everyone. We've had great engagement lately. I know the sun outside in BC at least may have some people working a little more from home or taking their vacation time right now. So hopefully we have enough questions to fill in the time. If not, I've got a couple topics that I'd like to touch on, just general kind of hot topics in employment law currently that may be of relevance to some or all people out there. So I'll just let everyone know if you have any questions, pop into the chat, ask away. Other than that, and if you're in any of our other jurisdictions, like Ontario, our next employment law session is with the employment lawyer himself, Mr. Lior Samfiru, and that's on Wednesday, the 27th at 1 p.m. So he'll be able to answer your Ontario, Alberta, and BC questions. He's a knowledgeable guy. So there's another opportunity, and we have these sessions spread throughout the weeks in various jurisdictions, various lawyers who will be coming on to answer your questions. We're always happy to do this and happy to get engagement from the public on this. So always remember to like and subscribe if you find these valuable, or if you want to just tune in and you don't want to ask any questions, you just want to listen and hear what other people are asking, go for that. So we have Steph D off of YouTube kicking us off here. Steph says, "Hi, are you still entitled to severance if your employer is letting you go and you have another job offer? It's a federally regulated industry." So Steph, that's a great question. It depends on a couple things. So there's a concept called mitigation, and that's what you're asking about essentially, which is your duty to find replacement work. How severance works is there's basically two types of severance. There's your minimum severance that's guaranteed under statute, which is not affected by mitigation. So you get that, for example, in BC, the Employment Standards Act of BC gives you a minimum of, it's set out in the legislation, but let's say you've been there for 10 years, you get a minimum of 8 weeks. That's regardless of whether you find another job. There's also common law severance, which, the rough rule of thumb is, about a month for every year you've been employed. So it can be much more, and you can get up to a maximum of 24 months. Let's say if you've been there for, 20 years, 30 years, and mitigation does affect that second type of severance, the full package of severance. Your employer essentially gets a dollar for dollar credit. Now, it really depends on when you find that work. For example, if you are terminated and you're only owed, say, 1 month of severance, and you find a job, within 2 or 3 months, that won't impact you. But let's say you're owed 6 months of severance and you find a job after 3 months. As long as your minimum entitlements are paid out, your new job income will be offset. And of course, if you from your severance. And so, of course, if you make the same as your old job, or more at your new job, it will wipe out your entitlement for severance from the date you get that employment forward. If there's a shortfall, then your severance claim for that period gets reduced to whatever that shortfall is, and you can pursue that. It's a great question. It's something we deal with, quite a lot, and it's a source of confusion for not only employees but employers as well as to how that's actually dealt with. If you are in a situation, even in a federally regulated industry, depending on your position, you may have access to other ways of getting that income as well. There's unjust dismissal provisions in the Canada Labor Code. There are human rights issues that could be looked at as well. So if you're in a situation where even you've been terminated, you think you're owed more, and you just want to check, give us a call. And give us your specific situation, and we'll be happy to talk it through with you and figure out whether you are indeed entitled to more severance or whether your severance entitlements have been satisfied. And you can go to employmentlawyer.ca. I think it's popped up on the bottom of the screen there, to book an intake appointment with us, to contact our intake team, or contact one of our lawyers directly in whatever jurisdiction that you're currently living in. So Steph, I hope that answers your question. Not a problem. And we have an email question in from Dawn. Dawn asks, I work in a union, but my employer has had to sign a separate non-union agreement for after hours and on-call work. I'm not sure what my rights are in this situation, but the pay for these shifts is low. What are my rights? So, Dawn, that's a unique situation. Usually you hear that a lot. I mean, we'd have to always take a look at the agreement if there is, you said there's an agreement there. So we have to take a peek at the agreement and see what the agreement actually sets out. If you sign the agreement, there's ways to break agreements, but it would really depend on the context in which it was signed. And the reason, for wanting to break it. If it's just you think you should be paid more, then that's perhaps a negotiation situation. Usually for union issues, you're stuck going through the union. We cannot assist. You're not allowed to hire outside counsel. It's dealt with in the whatever collective bargaining agreement that you're subject to. But here, if you've got kind of a second employment with the same employer for non-unionized work, regular severance entitlements, I assume, would attach to that. I don't see any reason why they wouldn't. But again, I'd have to take a peek at the agreement. If you are in a situation where you're worried about that, or you're looking for a consultation on that, feel free to give us a call. We do contract reviews and interpretations, and can give you a little more certainty once we review that contract. And again, you can go to employmentlawyer.ca, and you can contact us to set up a consultation and send us your documents. We can look it over and we can give you some specific advice on your situation. Okay, and it looks like, this is a double question here. Bill asks, from Facebook, Bill asks, Bill Petroza, is recording meetings between myself and my employer legal? So, Bill, this is a tricky situation. BC is a one-party consent state, or province. So what that means is one of the participants to the party has to consent to the recording. If you're part of that conversation, you can consent. The issue comes up where recording meetings between yourself and an employer without their knowledge could lead to a breakdown in the trust relationship between you, which could impact how it is either looked at, dealt with, or it could even bring one on. So it really depends on the reason why you're wanting to record the meetings. Generally, I would just advise people not to record meetings or surreptitiously record them. What you can do, however, which generally has a similar effect, at least legally speaking, is following a meeting, send a confirming email, take some notes, either in the meeting or immediately after, and send a confirming email to your employer to say, I confirm we just had a meeting at, say, 1:09 on this Tuesday, July 26th or whatever it is today, 26th. And this is what we discussed, and then have a point form list or of whatever you discussed, whatever was agreed on, if any agreements were made on anything, and if any tasks were doled out, or anything like that. Have that in an email, send that to your employer. And I always like the phrase at the end just to say, and sorry, Bill has a follow-up point here. They have a habit of saying one thing in the meeting and lying that they never said that in the meeting. So Bill, the email, the written email chain would be the best way to do this as well, is to set everything out that was said that you're concerned about or that's important to you, and to say, if I have any of this incorrect, please let me know. And that's their chance to object. That's their chance to set the record straight. And if they don't, you've got a great argument to say, well, listen, I gave them the opportunity to correct any misconceptions following our meeting. They didn't avail themselves of that, which to me says that they agreed with that, right? The time for them to object is at that moment there. So, I would say to protect yourself, especially if you're in a situation like this, Bill, I would just take some notes during the meeting or immediately after, send a confirming email that day, confirming the content of whatever was discussed or agreed upon, send that to your employer, and keep a copy of that. I would keep a printed copy. Don't rely on it sticking around in your desktop or anything like that, or email. Sometimes things happen. So I would keep a printed copy of the correspondence if you're worried about, that this could lead to a termination or a termination style scenario. All right. So Bill, hopefully that answers your question. And we have another question from a Bill Sullivan off YouTube. And so this Bill asks, sending me a registered letter threatening legal action against me for even talking to fellow coworkers, particularly regarding my supervision. Would this be bad faith? Submitted a complaint. So generally, I wouldn't say this would be bad faith. It's kind of confusing as to why you would be sent a registered letter for talking to coworkers and those under your supervision. I'm not sure what legal action they'd be taking against you. I think getting more information, Bill, as to whether this is a former employer and you perhaps have like a non-solicitation or a non-disparagement clause in your contract, or in a release you may have signed if you were terminated and took severance. I think, Bill, we need a little more information. This would be a situation where the wording of the letter and the exact nature of the legal action would be important to know. So if you are in a situation, it seems like you are where someone is threatening legal action against you and they're basing it off documents, or they're at least outlining their position, give us a call. You can email us and send us a copy of that letter. And then, I think you probably would want to have a consultation to at least go through and either inform you of your rights. You can email us there at help@employmentlawyer.ca. It's in the bottom of the screen. That's help@employmentlawyer.ca, and request a consultation. And we can kind of go through and see what you're maybe facing here, how best to position yourself, or best to diffuse the situation, or at least how best to protect you moving forward. All right. We have a question from a Martin Knight. Martin off YouTube asks, my employer is talking about selling the business. I'm currently on medical leave for health issues, but I still have a position if this happens while I am off. So Martin, that would entirely depend on the terms of the sale and the new owner. So if you are terminated by the sale, you would be owed severance, and what that would look like would depend on whether you have an employment contract, and if you do, the contents of that employment contract. In situations like this, when you're on medical leave and then your employer is talking about this, I would send an email asking your employer just to say, listen, what's going to happen with my employment? Can you bring this up with whoever you're looking at selling this business to? I'd like to talk to them. If you're terminated with medical leave, if it's because of the sale of a business, they're still going to owe you severance, either your old employer, or if your employment continues, then the severance obligations would transfer to the new employer, unless there's a term in the sale which restricts severance to the old employer. So there's a couple nuts and bolts to work out here. If you are terminated on a medical leave, generally, you have a human rights complaint and action available to you. In a situation where they're just selling the business, it's likely that you would be restricted to just a severance claim, I would say. But it would also depend on what happens. For example, if every individual in the business is terminated on the sale, then you probably won't have a human rights complaint. But if only you're terminated as a result of the sale and the rest of the employees are kept on, I think you got a pretty good claim for a human rights complaint there. So Martin, I would say, get a little more information, ask your employer directly. There's sometimes no better path than the direct one. Just ask the question, I'm on medical leave, you're talking about selling. If you do, can you let me know, and what are your plans for me? And to have that raised with whoever is purchasing the business, so you're at least not left out in the cold. And you can also, when you get those responses, or when the sale happens, contact us, contact an employment lawyer, and we can talk about where you're sitting at that point, depending on what the business and what the purchasers have decided to do. Okay. So hopefully that answers your question, Martin. We have another question off Facebook from Aaron. Aaron asks, my employer is enforcing shift changes during summer months and has put me on overnight shifts. I'm a single parent and cannot get childcare for this. What can I do about this? So Aaron, that's first, that's an unfortunate situation. As a parent myself, I can understand how difficult that would be to deal with, especially for childcare issues and whatnot. So A couple things would be relevant to this off the top of my head. A would be your current work schedule and what that looks like, and whether you do shift changes, overnight shifts currently, and what that looks like. It would also depend on your employment contract. In this case, your employer, because of you're a single parent and you have childcare issues, your employer has a duty to accommodate you. They can't discriminate against you based on your family status. And in this case, it would be because you have a child that you must take care of overnight, and so they have to make reasonable accommodations. For example, if there are other individuals who can do overnight shifts, and that would allow you to do day shifts, which would accommodate your lifestyle, then that's something that they should be looking at doing. I would say, you definitely would want to call in for a consult just to help talk you through this and at least position you appropriately. Send in your contract, any communications dealing with the shift changes. I think your first step should really be to talk to your employer, to send them a email in written form to say, you switch me to overnight shifts. Usually, I'm glad to accommodate or whatnot, but because of my childcare situation, I can't. This is why I cannot do it. It's because I'm a single parent, I have a child, and I cannot do these overnight shifts. Please keep me on my current shifts. And I'm assuming your current shifts would be day shifts or morning shifts or something of that nature. And that would be your first step, and to ask for accommodation, to say, can you please accommodate me because of my childcare needs, and to see what your employer responds. Typically, that will trigger the employer to either seek their own legal counsel to say, okay, what are our obligations here? Or to say, okay, we didn't think about this. Okay, this can be too difficult for Aaron. So let's see what we can do to help him out here. They may be able to say pay for childcare or help you find that if that's going to be an option, or they may switch you around your shifts. So hopefully that gives you a bit of direction, Aaron. And I think once you send that email and get a response from them, if it's not a positive response, you can go to employmentlawyer.ca. You can talk to any number of us. I'm happy to speak with you and to give you some guidance moving forward, depending on what your employer responds. Hopefully the employer does the right thing and works with you to find something that works for not only the business, but for your home needs as well. All right. So best of luck, Aaron. If you have any other questions, contact me or contact anyone at the firm, provided you're in BC or Alberta or Ontario, and we'll do our best to help you there. And so Bill Sullivan has followed up here. We have submitted harassment complaint about my supervisor. I was let go without cause and paid statutory minimums. Okay, so Bill, if you were terminated following submitting a harassment complaint about your supervisor, that can be a prohibited action. So I would contact WorkSafe BC. That would be a first step, just to lodge your complaint and to get that process started. Whether you are owed more than statutory minimums, it is of course going to, I always talk about this, it's going to determine whether you be determined by whether you have a contract and the contents of that contract, if there's a termination clause, and more than that, if there's an enforceable termination clause, because, not all termination clauses are equal. Some can be broken, and so I always say, if you have a contract and a termination clause, don't stop the analysis there, send it in to us. We're happy to do a consultation and speak with you and take a peek at the clause and give you an idea, at least, as to whether you're entitled to more. And Bill, I would say in your case, try to book a consult with us. I'm happy to speak with you myself, but definitely contact WorkSafe BC, provided you're in BC. And if you're in Alberta or Ontario, contact the corresponding authorities and the workplace authorities, and lodge a prohibited action complaint. Because that's something that they're not allowed to do if the reason they terminated you is because of the harassment and following the harassment complaint. All right, and we have Bruce. Thank you. I appreciate the comments. And we have another question in here from Aeus on Facebook. Aeus asks, I left my job a couple months ago. I had almost 50 hours of vacation that was not paid out to me. What are my options here? So if they withheld vacation time that you're owed and that's been accrued, I would talk to the Employment Standards Branch. You can lodge a complaint there directly yourself for the payment of that vacation pay. Alternatively, you can contact us if there is other pay that you're looking for as well. We're happy to assist you with that. If the vacation pay is, say, banked pay, over a period of time, say over a year, Employment Standards Branch can typically only go back about a year to recover payments, and there's a 6-month deadline from the date of your termination to claim that. So I would do that very quickly. From the date of your termination, you've got 6 months to lodge an employment standards complaint with the Employment Standards Branch. I would do that immediately. And contact an employment lawyer to see what your rights are in respect of your specific situation. All right, and off YouTube we have another question from Ev M. Ev asks, can your employer change your pay from hourly to salary? If you choose not to agree, can they terminate you? Okay, so Ev, that's a great question, and it's a somewhat nuanced one. So it really depends on what the impact to your pay is going to be, the reason for the change. For example, if it benefits you, then generally your employer can change your pay within a certain range. My comfort level, I usually tell people, is the golden number, so to speak, is around 15%. If your compensation drops by more than 15%, you've got a good claim for constructive dismissal potentially. It really depends on the scenario. Depends on your specific employment agreement, your specific type of employment, what kind of work you do, and how and why the salary change is happening. It's not entirely clear to me that you are going to be suffering a drop in salary, moving from hourly to salary. A drop in pay, moving from hourly to salary. My guess is that the goal of that is to remove things like overtime. Perhaps you're putting in a lot of overtime. This would be a potential way for the employer to get around paying you overtime moving forward. That's the first part of your question is, they can technically do whatever they want, and it just depends on how you deal with it. If you accept the change, you're perfectly, able to do that and move forward. If you don't want to accept the change, or if the change is going to have a very detrimental impact to you in terms of, pay, benefits, something of that nature, contact an employment lawyer before you do anything. I always tell people that if there's something like this coming down the pike, if your employer is talking about making changes to your agreement and you're very unsure about it, best thing to do is we need specific information. We need to see what your current agreements are. We need to see what the proposed agreement looks like. We have to give very specific advice on this because it's not a guarantee you can claim a termination every time, but there are situations where you can, definitely. So Ev, I would say, contact us. And to the second part of your question, if you choose not to agree, can they terminate you? Yes. Your employer in BC can terminate you for any reason as long as it's not a discriminatory one, and as long as they pay you the appropriate amount of severance. So in this case, if they're choosing to renegotiate your contract, and provided you're not on a fixed term contract, you're just on a general indefinite contract, so you haven't signed a contract that says you're employed from X date to X date, your employer can change that. And if you choose not to agree, they can say, well, this is the only employment we're willing to offer you moving forward. If you don't want to take it, we're going to terminate you. In that case, you would be owed severance. What that severance would look like would, of course, depend on your employment contract. So I would say give us a call, get a consultation, and we can give you some specific advice once we've reviewed your specific documents. All right, so we have an email question from Ashley. Ashley says, I work in medical equipment sales. My employer has said that we are not entitled to standard severance because of our industry. Is that correct? So, Ashley, that there are certain industries, professional industries, that are excluded from employment severance, standard severance. So standard severance, I'm not quite sure what you mean by that. In either event or in any event, you're still entitled to severance. Whether or not you're entitled to your minimum severance, you have to double check the legislation. Again, I haven't seen medical equipment sales in a while. But no, off the top of my head, I would say that that's not true. I'm not sure what your employer means by standard severance, but you would be entitled to common law severance, provided you don't have an employment contract that limits you to your employment standards minimum. So there seems to be a bit of a disconnect here. Either you're going to have an employment contract that says you're entitled to minimum severance, your employment standard severance. But if your employer, and what I'm getting from here is your employer says you're not entitled to that, that's fine, because you're then entitled to common law severance, which is more, which is the 1 month for every year you've been employed, roughly. There's a number of factors that go into that to uptick or downtick that amount, but that's the rough rule of thumb when you're looking at it. You can also go to pocketemploymentlawyer.ca. That's a site we've created to help the general public. You can put in your information there, length of service, your industry, your age, and it'll give you an idea of what kind of severance you're looking at, what your entitlements are. So I would do that and give us a call. In any event, I would say you're still entitled to more than your employer seems to be wanting to give you if this is how the conversation is going. And so, okay, we have another follow-up question from Martin Knight from YouTube. Would a new owner be able to refuse workplace accommodation if I try to return on modified duties since they didn't technically hire me themselves? No, Martin. So the accommodation request sticks with your employment. So if if there's nothing in the sale agreement, the sale of the business agreement that requires the termination of all employees and the paying out of severance from the old employers, then they've taken on your employment. Your employment continues with them. The accommodation request sticks with your employment. They can terminate you. They can still say, listen, Martin, we can't accommodate you for X, Y, and Z reasons, but we're happy to pay you a reasonable severance package and help you on your way. That's an option as well. But the duty to accommodate would attach to the new owners. So that you won't be left in the cold, at least on that end. And so we have a couple questions. So Scott from YouTube asks, company was sold 1.5 years ago, been with the company 25 years, shutting down permanently, severance offer of 16 weeks. So Scott, I assume the company was sold 1.5 years ago, but they're now only shutting down, and you're getting an offer of 16 weeks. So, that's not enough. I would say presumptively that's not enough. I mean, there's a couple things that would go into properly evaluating this, how many employees are in the company, whether you have an employment contract. You can go to pocketemploymentlawyer.ca and put in your information there. I can tell you off the bat that being there 25 years, depending on what your position was and what company you're with, what type of industry you're in, you could be owed as much as 24 months. Definitely with that type of a tenure, you can be owed as much as 24 months of severance, so 2 years. So the 16 weeks or the 4 months is, I would say, not enough. This is all obviously depending on whether you have an employment contract that may limit you to that. And then that is a reality that could come to pass, where you have an employment contract that limits you to your minimum severance. And if you're limited to your minimum severance and by a termination clause, and it's enforceable, given even that you've been there for 25 years, you could only be entitled to 8 weeks. So I would say before you sign off on anything, please don't sign it, with anyone. If you get an offer and you have questions about it, and you sign a release or you sign a settlement agreement, you're basically stuck. So give us a call, Scott. We'll do a consultation for you. You can reach out to me directly. I'm happy to speak with you and run over the scenario and review the documents for you. And it looks like we have a couple other questions, but we are out of time for today. I do apologize for any questions I was not able to get to. Great engagement today, everyone. I appreciate it. I hope you guys find this valuable. I love doing this. Love being able to help people. And this is an opportunity for us to be able to do this on a kind of a quick scale. I'll be back in 2 weeks. You can come on Wednesday, the 27th at 1 p.m. Eastern time. You can talk to Mr. Lior Samfiru himself. And you can have any of your additional questions answered. All right. Thanks, everyone. Enjoy the sun and take care.